So good morning and afternoon to everyone, depending on where you are. But welcome and thank you for attending today's webinar that we're running for you, which is Explaining the Fair Work Amendment, Closing Loopholes Bill. On behalf of the business, we thank you for taking the time off to watch this webinar with your busy schedules. The positive news is that it looks like we have a good amount of people who have already jumped into the webinar so far, which is great. We're just waiting on a couple more people to join, then we'll kick it off. So please just bear with us for a few more moments. Okay, it looks like we are ready to get on with it. So ladies and gentlemen, a very warm welcome to you all. My name is Adam Aliagich and I am the Senior Business Development Manager here at HR Assured. So it's my job to help businesses find the right workplace solution to ensure they are staying on the right side of the law. As you may be aware, Australia has seen a multitude of workplace law reform in recent times. Both the Secure Jobs, Better Pay Bill and the Respect at Work Bill have both made significant changes to our employment law framework and the obligations of employers around the country. If you thought these law changes were big, think again. As you know, in early September this year, the federal government tabled the Fair Work Amendment, Closing Loopholes Bill 2023 into Parliament. The reforms proposed by the bill will substantially impact workplaces across the country. And at our webinar today, our experts are going to tell you exactly how that business might be, exactly how your business might be affected and how you can begin preparing for these changes. Just before we get started, I have one housekeeping rule. I am sure that throughout the presentation, you will have questions, which is great. And if you do, I just strongly encourage you to use the Q&A function located at the bottom of the screen. We're definitely keen to help you do so and answer the questions that are there. So please don't be shy. And we will make sure that your identity is not revealed. We'll go through as many of the questions as we can towards the end of the webinar. And one more thing, this webinar is being recorded. We will share this with you after the presentation, so please look out for an email from myself. So before we get started, I would like to introduce you to today's speakers. To talk through the Closing Loopholes Bill, we have Wes O'Donnell, our National Workplace Relations Manager, and Law Elise Kenworthy, a Senior Advisor on our TAS team. Wes and Law bring a wealth of experience in interpreting the Fair Work Act, and we are lucky to have them to run through what these changes are and what they mean for you as a business. You may or may not be aware of the FCB family. For those who are, welcome back. And for those who aren't familiar with our organisation, on your screen are all the current members of the FCB family. So we'd like to say that we can be your one-stop shop for HR and work health and safety. Starting in the top left, we have FCB Workplace Law, which is one of the leading and award-winning workplace relations law firms in Australia. FCB Law has over 30 years of experience in the field and is the backbone of where we get our expertise when it comes to managing employment law and the health and safety. And FYI, we have 5 accredited employment law specialists within FCB Law, which is the most accredited employment law specialist in Australia. You will also see that we have FCB Smart Visa, which is our immigration and migration practice. Jumping over to the bottom left, we have Enable HR, which is our technology solution for FCB. But under the banner, which we are talking to you today, finally, QMS and Best Practice, they are the newest members of our family. Both QMS and Best Practice will be able to help you out if you are looking at ISO and NDIS certification for your business. But as I said, the banner under which we are talking to you today is in the top right, which is HR Assured. HR Assured is a fully outsourced HR and work health and safety solution for businesses designed to give you peace of mind that all your HR and WHS matters are handled compliantly and efficiently. So how do we do this? Firstly, we conduct a workplace, an HR, comprehensive HR audit and a health and safety audit. What these audits do is they look at your contracts, policies, and procedures, so documentation on both levels of HR and work health and safety, provide you with two very in-depth reports identifying where there might be gaps and risks. At the end of that report, the good news is it's not left to your own devices. We will then help you redo documents and help you implement processes and fix up any issues that there might be. Going on from there, we do understand that there are issues on a day-to-day from HR and work health and safety. So you do get access to a 24/7 telephone advisory service, which goes through to the likes of Law and Wes. Those questions could be around bullying, harassment, awards interpretation, mental health in the workplace, or such as questions today around changes in legislation. We provide you with our HRIS system, which is HRA Cloud. HRA Cloud is there to manage the employee lifecycle. So from your pre-employment to your employee management, all the way up to termination. Think of things like paperless onboarding, induction processes, poor performance meetings, and termination and offboarding out of the company, as well as record keeping. You can also manage your work health and safety in the same system. So things like hazard, incident reporting, return to work of injured workers, and so on. There is a massive library of legal resources and work health and safety policies and procedures built in. Finally, we do give you an advice promise, meaning that, for example, you wanted to terminate an employee, you call through to the advice line, we give you advice on that termination, agreeing, saying, yes, that is grounds for termination. That ex-employee then decides to go to the Fair Work and lodge an unfair dismissal claim. Our law firm, FCB Group, will represent you in court with no additional legal fees or excess. And if there is a settlement or payout that needs to be made, we will pay that out as an uncapped amount. With that, I'd like to hand it over to Law, who will now present the next part of the webinar and the reasons you're here. Over to you, Law.
Thank you so much, Adam. Thank you for that introduction. So if you can have a look at the slide there, you'll see today's agenda. We will be talking about the Secure Jobs Better Pay legislation, the Respect at Work legislation, some practical compliance steps that you can take in your business to ensure that you are up to speed and compliant with those changes, because as Adam said, there have been so many. The Closing Loopholes Bill, which my colleague Wes will speak to you about, casual employment, same job, same pay, independent contractors, wage theft, and then we will provide you with an opportunity to have your questions answered. And as Adam said, if you have any questions throughout the presentation, please provide those through the question box and we will attempt to get to those at the end. Now, we had 13 years of a Liberal government, and after that time we had a Labor government come in off the back of a number of significant promises of industrial relations reforms. And we saw those come into effect in late 2022 substantially. So there was a process of consultation instigated by that government involving the federal government, unions, employers, employer organisations, the result of which was the decision that there would be some significant reforms over the course of this year that we've seen. We have delivered at HR Assured a number of webinars in respect of some of those core changes that have taken effect to date. But the purpose of today's presentation isn't to go so much into the depth of those changes, but to canvass them, to rehash them at a higher level, and to give you some tools and practical steps that you can take to ensure that you are compliant and up to speed in your business. So I will be starting with a canvassing of the Secure Jobs Better Pay Act, which was passed in Parliament on the 2nd of December 2022, so last December. Now, it is better known as the Secure Jobs Better Pay Act. It is formally titled the Fair Work Legislation Amendment Secure Jobs Better Pay Bill. And it introduces a number of significant changes to the workplace relations framework. These changes span complexly between December 2022 and December this year. And I will cover some of those core changes for you now. So the objectives first of the Fair Work Act have been amended effectively on the 7th of December 2022 to include promoting job security and gender equality. In addition to that, down on the bottom left side of the screen there, you'll see prohibiting pay secrecy. So what that's talking about is from 7 of December 2022, it became unlawful for employers to include a pay secrecy clause in contractual provisions that prohibit employees from discussing their salary or remuneration. As a result of this reform, employers should have already essentially got their house in order by making changes to any contracts that may be in breach of those new provisions. If they haven't already, importantly, there can be some penalties involved for non-compliance with the relevant civil remedy provisions. In addition, there's been changes in relation to enterprise bargaining. So or there will be rather, excuse me, from the 7th of December 2023, all zombie agreements will be automatically, or they will automatically cease to have effect unless their operation is extended by the Fair Work Commission. Employers whom this applies to should have issued a notice of applicable automatic sunsetting by the 6th of June this year. And if they haven't, there may be civil penalties imposed for that failure to do so. So another important change that's taken effect that employers will need to have been attended to prior to this time. That's certainly something we can support you with if you haven't. Now, there's also been some changes to the flexible working provisions. So from the 6th of June, so recently this year, the right to request flexible working arrangements has been changed to now apply to employees or a member of their immediate family or household who are experiencing family and domestic violence, and employees who are pregnant. Employers, importantly, should now be across these changes because they need to take certain steps before they can refuse such a flexibility request. Some of those steps might include, for example, discussing the request with an employee and making a genuine effort to find suitable alternative arrangements. These are just a couple of those steps that it's important that employers are taking in response to a flexible working arrangement request of the nature I've just described. And so in order to it is important that employers are aware of the full suite of those obligations in order to be compliant, should such circumstances be relevant. We also importantly have some significant changes in light of, sorry, I'll just jump back a slide, in light of fixed term contracts. So just down in the middle of the slide there at the bottom, from the 6th of December this year, employers may not engage employees on fixed term contracts exceeding 2 years, and this includes renewals for greater than 2 years in total. This includes anti-avoidance provisions and exceptions for certain roles and industries, including contractual purposes, where that prohibition will not apply. There's also going to be a requirement, importantly, that they're provided with a fixed term contract information statement. Now, you may already be aware of the Fair Work Information Statement, the Casual Employee Information Statement. This is a further statement that will need to be provided to relevant fixed term employees from the 6th of December. These changes were introduced at the end of last year, as I mentioned before, but there's been a 12-month grace period afforded essentially to allow employers to get their house in order, to make sure that they're assessing their fixed term contracts. And we certainly recommend that this already be something that employers have done if you do have a fixed term employee or employees. And if not, this is the time to be getting your house in order. Now, the next significant amendment, act or bill, is the Respect at Work Bill, which now referred to as the Respect at Work Act. This was something that's come off the back of significant Respect at Work amendments resulting from what you may remember being the Respect at Work Report 2020. So there were a number of recommendations that came out of that, which were tended to through different reforms over the last couple of years. But most recently, we've seen in November last year, the Anti-Discrimination and Human Rights Legislation Amendment Respect at Work Bill 2022. And if the title of that doesn't reflect the complexity of the changes, I don't know what does. Now, you can see some of those 4 key changes on the slide there, and I'll address the top two in more detail than the bottom two because of their significance. But just to canvass those bottom two, there are some enhanced powers of the Australian Human Rights Commission. That's what the AHRC stands for. These will be amended. These changes will take effect from December 2023 to essentially expand the investigative and enforcement powers of the Commission. The reason for this delay is, again, to allow employers to get their house in order, to make sure they've taken those steps to be compliant with their new obligations, because there's a general recognition that there are so many and significant changes for people to be across at the moment. So, for example, the Commission is going to be able to conduct inquiries into employer compliance with the positive duty, which I will address. It's the top right point on the slide there. So it will be able to conduct inquiries into compliance where there's a reasonable suspicion of non-compliance. It's also going to be able to provide recommendations to employers regarding failure to comply with the positive duty. And those are just two key examples of some of the things that have changed for the powers of the Commission, some of those key ones. In addition, there's going to be an increased power for the Commission to hear disputes and to increase the penalties imposed on non-compliant parties or employers. So because of this, it is important that employers are across and compliant with those new obligations. Now, to attack some of those top two key changes. The first is the positive duty to eliminate sex discrimination. And I would not be surprised if some of you who are listening today have heard of this referred to as just the positive duty. That is the shorthand reference to what I'm explaining now. The positive duty is probably one of the most talked about changes for this bill. And it's seen the inclusion of a positive duty to eliminate sex discrimination within the Sex Discrimination Act. Now, amendments to the legislation set out this positive duty for employers and persons conducting a business or undertaking, which is your PCBU listed on the slide there. The duty is to take reasonable and proportionate measures to eliminate, as far as possible, unlawful sex discrimination, sexual harassment, which includes harassment on the ground of sex, hostile working environments, and acts of victimization. Importantly, when the Commission is determining if a duty holder has complied with this positive duty, it will consider factors including those listed on the slide. So you've got things like the size of the business, the resources of the business, the practicability of taking costs to eliminate conduct that is covered by that duty, and so on. Now, relevantly, you would think it might be defined, but positive duty itself as a term is not defined. But what is a reasonable and proportionate measure will depend on those factors that I've just outlined on the screen there. Importantly, before we move on, I must iterate that because of where we're at with this legislation now, it is important that people or employers have already taken proactive steps to satisfy this duty. To draw a distinction between this change now and the previous position of the legislation, previously the employer only needed to demonstrate that they'd taken reasonable steps if they were trying to defend an argument or claim that they were vicariously liable for sex discrimination. That was considered a reactive provision. And what we're seeing now with this positive duty is that you need to be on the front foot. You need to be able to demonstrate that you have taken reasonable steps to ensure that sex discrimination isn't going to occur in the first place. So you need to take positive steps, and that's hence the reference to positive duty. And we can certainly provide, examples of positive steps are you have a policy in place, for example, and you conduct training with your employees in your workplace. But whilst these are just two key examples, there are certainly many others that could be appropriate for your business, depending on the nature of your business, where you're at in the stage of your business development, and many other factors. So there's much more to be said about that, and that's certainly something we can support with if that is a concern of yours. Now, the next key change under this Respect at Work legislation is in relation to hostile workplaces on the grounds of sex. Now, the Respect at Work report that I referred to before, which came out in 2020, or was published in 2020, it found that sexual harassment can occur where a workplace environment is sexually charged or hostile, even if the specific conduct isn't directed at a particular person. And that is the crux of this hostile workplaces revision. It was noted in this report that conduct such as displaying obscene or pornographic materials, general sexual banter or innuendo, or offensive jokes can result in people of one particular sex feeling unwelcome or excluded by the general environment around them. And this has been recognised as actually increasing the risk of people experiencing other forms of unlawful discrimination, such as sexual harassment. So while courts have actually recognised that the previous provisions of the Sex Discrimination Act have provided for protection where there's a hostile work environment, it wasn't previously well understood. And so these changes are really building out these provisions. The amendment actually provides clarity, therefore, and certainty to the law, to the sex discrimination legislation, and sets clear boundaries about what is going to be deemed acceptable conduct in the workplace. It prohibits a person, this is a specific prohibition, it prohibits a person subjecting another to a hostile workplace environment on the grounds of sex. And it doesn't have to be directed to a particular person. It can happen in the workplace around somebody who experiences that in a negative way, and that may be unlawful. It includes conduct such as unlawful sex discrimination, sexual harassment rather, and as a part of this, I think importantly, this sits side by side with the positive duty. So if you're taking positive steps in relation to the obligation to minimise sexual harassment in the workplace, it sits hand in hand really with making sure that you have a workplace free of hostility of a sexual nature in accordance with these provisions. Now, I believe that brings me to the summary of essential key dates as a product of these changes. And this is where it's important, I think, as a listener here today, that you're kind of aware of the timeline of changes and just to know where you stand, what steps should have been taken to date, and what steps need to be taken by the end of this year. So we're looking on this slide at some of those changes that enacted in December 2022. Importantly, some of those, such as the zombie agreement sunsetting, don't actually take effect until the end of this year, but we have had changes like the pay secrecy right to disclose already take effect. That already needs to be, employers already need to have taken steps to ensure compliance with that prohibition. In addition, we've got the prohibition from March this year of sexual harassment and an increase in the Fair Work Commission's dispute-related function for that. Something I haven't noted but is on the slide there, you've got from the 1st of February this year, the paid family and domestic violence leave entitlement. That is something that we've addressed in prior slides, in prior presentations, but it comes hand in hand with these changes. Now, pay secrecy, that has taken effect from the 6th of June, so only a recent change, but equally important that now that we're past that date, employers are taking steps to ensure their compliance with those provisions. Now, off the back end of, I suppose, earlier this year changes, we've got a couple more from June this year on this slide. So changes to flexible work requests, and I'd spoken to you about parental, rather pregnancy-related flexible working requests. And that also comes hand in hand with changes to extending unpaid parental leave that have occurred earlier in the year. Again, not something that we'll go into detail in this presentation. Toward the end of this year, so you see those kind of blue coloured lines which are going to draw out for you those changes that are really important for you to identify and be aware of coming into the back end of this year. So we've got knowing that fixed term contracts are not able to extend beyond 2 years, including extensions of the contract or fixed term contracts consecutively. We've got the introduction, but again, of the fixed term contract information statement from December. And we've got the sunsetting of zombie agreements if your organization has an enterprise agreement. I suppose the icing on the cake with this is that we also have those extended commission powers coming in from December this year, which means that if you haven't taken steps, if you're not across the changes, you could be at risk of the effects of these increased powers of enforcement and penalties associated. So there's a lot to take in there, and I absolutely appreciate that. This is kind of like a high-level overview here for different businesses, but whilst I can give you some practical steps here, and I will, we recognise, and it's something that we do as a part of our day-to-day service, is to recognise how different businesses have different needs. And so these practical steps are good for everyone to take into account, but they may not cater to your exact business. And that's where I will defer back to my colleague Adam in a moment, and he can give you some advice as to how to reach out to us if you do need some of that bespoke guidance for your business. In terms of practical steps, with pay secrecy, it's important that you've actually looked at your contracts rather than a set and forget approach. It's important to look at those and make sure that they've been updated. So you have changed or removed any provision that says essentially your remuneration is going to be considered confidential. It may be appropriate to also consider your remuneration structures for different employees or employees in the same role within the business if there are different remunerations applying to those individuals. And that goes toward improving this gender pay gap that's been recognised as a product of these amendments I've spoken about. Fixed term contracts, we advocate for people actually taking those steps now of reviewing their fixed term employees and fixed term and maximum term engagement models. Consider whether or not there is going to be, or these provisions are actually going to apply to you. Are you going to be exempt as a product of perhaps some funding model that applies to the way you organize or you run your business? Or is there no exemption, in which case you really need to look at how you're going to restructure your contracting of employees? Absolutely, we understand that sometimes there is complexity in the way businesses operate and the way they interact with other businesses. So if you've got particular concerns about that, again, Adam's going to provide some contact details following this. In relation to the Respect at Work changes, it's important that you're able to identify the risks so that you can then actually look at what reasonable steps, proportionate steps you can take to respond to those risks. We absolutely advocate for creating a strong reporting culture so that where incidents occur, there's a way to actually address them and identify them. And of course, implementing policies and contractual obligations that align with your company values and a zero tolerance approach. A part of that, again, as I mentioned before, is conducting awareness training. That's something that we can potentially provide support with if that's something that people need. And absolutely give us a call for a conversation in relation to how we can support that. But look, that's probably a high-level canvas at this point of some of those best practical steps that you can take. And I think I now need to hand back to my lovely colleague, Adam. Thank you so much.
Thanks, Laura. Really appreciate that. And Laura is a great example of, I guess, the knowledge and expertise that you'll get through the advice line. So guys, if what you've heard so far has made you a little bit worried about what you currently have in place, or maybe a lot worried, to protect the business in regards to the Fair Work Amendment, we are happy to offer you a free workplace compliance consultation. This is a service that will, uncover any hidden risks and threats to your business, navigate and understand if your business is compliant with workplace laws, give you some tips to help your business succeed and improve your workplace processes. And there is absolutely no obligations. So if you'd like to scan that QR code, by all means, please do, and you'll be able to book in. If you are doing this on your phone currently and cannot, there is a link at the bottom there that you can see. So if you follow that, you will be able to book in. So with that done, I will now hand over to Wes.
Thanks, Adam. Thanks, Law. Appreciate the handover. As Law was mentioning, the change and the pace of change this year in our industrial framework has been rather significant, and that has continued with the recent introduction of the closing the loophole legislation, which was introduced on the 7th of this month. Now, this legislation is slated as the more controversial of the three pieces of legislation introduced by this new Labor government, and addresses some of the more significant aspects of their industrial relations platform, including the very definition of casual engagement, wage theft, significant penalties, and others. Now, one of the complexities we're seeing with particular clients, excuse me, is the complexity of the legislation already introduced, the range of obligations to address those statutory obligations, which continue, as Law outlined, but also trying to grapple with what the nature and effect of this new significant piece of legislation will have for many businesses. So we're going to go through in the style of Law, not necessarily addressing the technicalities of the legislation, but rather the practical implications as we see it, and trying to support businesses in appreciating what's going to come down the pipe and how you can get ready for that. Now, as I mentioned, the legislation was introduced, or the bill was introduced into Parliament on the 7th of September. While the Labor government rather, sought to introduce that with pretty quick succession, the opposition has been successful in pushing the legislation into a Senate reference committee, which will undertake a review of the draft legislation and provide a report in February. So given that process, we don't anticipate that there will be any substantial debate in Parliament upon the legislation until at least February of next year. And of course, given the numbers in Parliament, we expect that the legislation will pass at some stage, although many commentators are already suggesting that there will be some significant amendments around the fringes. So that being said, I wanted to focus on some of the more significant but practical aspects. Probably the most significant aspect, which will impact most businesses, given that most businesses at some stage will engage a casual employee, is the definition of a casual employee. Now, as we know, there's been some significant case law in the last 2 years concerning the nature of casual employment and the definition of what is considered to be a casual employment, and resulting obligations which arise from that. Now, as a result, there has been some degree of confusion around what is deemed to be a casual, and there's been various changes to law to reflect it, meaning that currently a casual employee is an individual described as such. Casual is a person described as a casual employee. Despite that, the proposed legislation seeks to return us back several years to where that concept is not necessarily as clear as the definition within someone's contract of employment, but rather views casual employment not just upon the actual definition as contained within a contract, but also the substance and practical reality of the relationship. Now, this obviously will lead to some level of dispute at the workplace as to whether someone is properly classified as a casual or more appropriately classified as a permanent employee, and therefore be entitled to backdated permanent rights. And it is a significant change following the very significant case law which has come down in the last couple of years. In addition to that, the government is very mindful around creating pathways to permanency for casual employees, viewing that casual employment is necessarily creating a level of disutility in those employment relationships. That is, there is an inherent disadvantage experienced by casual employees given their lack of security, inability to obtain loans, difficulties in maintaining personal affairs, family life, etc. And as such, the government has introduced a new pathway to permanency, which is a variation to the existing casual conversion provisions. Now, as we all know, rather controversially, casual conversion provisions have been implemented some time ago. It has created and led to significant administrative burden on many businesses in having to consider whether someone should or could be offered permanent employment, and then having to undertake a process to at least offer that casual permanent pathway, which an employee can either reject or dispute. We haven't seen, however, that a significant number of employees, casual employees, have taken up permanency as a result of those casual conversion provisions. And as such, the draft legislation has created a new pathway such that after only 6 months of employment, not 12, 6 months, that is for large businesses, or 12 months for a small business, which is a business employing fewer than 15 employees. An employee can simply notify their employer that they no longer consider themselves to be a casual employee given the regular and systematic work that they're performing. Now, this is generally referred to as an employee choice definition pathway, which is somewhat bizarre from a concept in that I no longer consider myself to be a casual employee, and upon notice, I'm informing you that I consider myself to be a permanent. Now, of course, the legislation does involve some degree of review on the part of the employer, meaning that the employer can reject that notification, but on very limited grounds. Those limited grounds are generally referred to as reasonable business grounds. However, it's interesting to note that the legislation's been updated to remove the ground that it is unlikely that there is a substantial change of hours of work, or that work will no longer be required in 12 months' time. So that was one of the main grounds that many employers sought to rely upon, stating that the number of hours available to casual employees is somewhat uncertain, and use that as a basis upon which to reject casual conversion. And that basis has now been removed from that employer choice pathway. As we've seen in the two acts that law has previously mentioned, this particular piece of legislation has also expanded the powers of the Fair Work Commission to enable it to handle and resolve disputes, including by way of arbitration if the parties agree. The legislation has also included new references to what is referred to as a sham casual, and indicating that there is significant anti-avoidance provisions which prevent unreasonable refusal to convert a casual employee, including significant penalties which may arise. I can already sense the frustration on many employers, and if that's not enough, there is also a new obligation indicating that there is a new requirement to again issue the casual employment information statement at the point of 12 months after service. The current wording of the legislation will mean that effectively we're having to duplicate that process, with the intention that we are reminding employees after 12 months of service of their right to seek to convert and the conversion pathways available to them. It really does show that there needs to be a structured approach to the engagement of casuals and the process of considering those casual pathways, but also the timing and reminder of sending out those casual employment information statements, because failure to do so is of itself considered a breach of the Act, and penalties may arise. Now, the next provision I want to talk to is generally referred to as same job, same pay. And a lot of media attention has been focused on this around the use of on-hire labour, which is a particular terminology that is used by the government and unions around insecure work. That is, businesses inappropriately outsourcing labour or using labour hire for a purpose of undermining the permanent employment rights of direct employees. So, same job, same pay is a provision of the new legislation which refers to the ability of any on-hire worker to seek an order of the Fair Work Commission, stating that they should effectively receive the same terms and conditions of any direct employee employed under an enterprise agreement. Yeah. So just to go through that again, on-hire worker placed to work at a host. The on-hire worker is paid terms and conditions which are considered to be less than the direct employees under an enterprise agreement. Now, the intention of the legislation is to ensure that those people working side by side, whether they be direct employees and on-hire workers, are achieving the same terms and conditions for doing the same work. So effectively, an on-hire worker or a person on their behalf can seek an order of the Fair Work Commission, which effectively enables them to receive the same employment terms and conditions as a direct employee. There are, however, a couple of significant amendments. The first is that this amendment will not apply to small businesses, that is, those engaging fewer than 15 direct employees. Now, personally, don't think that that's a significant exclusion in and of itself, given that there aren't a significant number of small businesses either engaging on hire labour consistently or small businesses who use or utilise an enterprise agreement and engage on hire labour on a consistent basis. There's also an exclusion where generally it's a 3-month exclusion period, which is intended to cover surge work or where individual on-hire workers are brought in to replace direct employees on short-term absences. So that implies that where there is the need to engage on-hire workers legitimately to address short-term deficiencies in labour or surge requirements, or because of a temporary absence of a permanent employee, then these provisions won't apply. There has been some significant contribution by people in the sector around the practical nature of how this will work. And there are provisions which have been included stating that an on-hire host, so that is the host organisation, must comply with any reasonable request by an on-hire provider to provide information necessary for compliance purposes. So I do think that this particular provision will get a lot of media attention. We're already seeing that there are media campaigns run by various lobby groups and associations, including agricultural associations. So I anticipate that this will be fiercely debated and perhaps some amendments around the fringes around this particular requirement. Another significant change which will impact particular industries and sectors more than others is the introduction of what's called an unfair contract provision. These provisions relate to or provide an easy pathway for independent contractors to dispute the fairness or equity of particular clauses within their contractual terms. Whilst there are in some states legislation which relates to unfair contract provisions, it was a relatively difficult and complex process to pursue, meaning that many independent contractors didn't really pursue that as an option. This particular amendment will create an easy pathway for independent contractors to bring a dispute before the Fair Work Commission, arguing that particular contractual provisions are either harsh, unfair, or result in unreasonable requirements on them as a party to the agreement. As a result, the Fair Work Commission will generally have broad powers to vary or set aside particular contractual provisions to create a more balanced and fair outcome, taking into account the relationship between the parties. Now, this is a pretty significant amendment for any of those who utilise or engage independent contractors, and is a pretty significant change in sectors and professions which frequently engage independent contractors, particularly in allied health, I can think of, IT, professional services, and others. Now, this will mean that will be the ability of the Fair Work Commission to take into account things like the respective bargaining power between the parties, whether there is a significant imbalance in the contractual obligation of the parties, whether terms are considered to be harsh, unjust, or unreasonable, and if there is a resulting loss in remuneration as compared to employees or contractors performing similar services. So, significant area, and it'll be really interesting to see those which take up that particular opportunity, particularly in the industries which I've referenced. Another significant change in the context of independent contractors is a return to a previous position of, I think, somewhat of ambiguous meaning in terms of who is considered to be an independent contractor. Prior to a decision in late 2022, there was always a sense of ambiguity around what would be properly considered to be an independent contractor and that of an employee. And after a significant period of time and a number of cases, the general position was that it would be determined by way of what's called a multi-indicia test. That is, the courts would review the totality of the relationship to determine whether it is more appropriately viewed as a contractor relationship or that of an employment relationship. In late 2022, the High Court determined, and this was a significant decision in the context of a definition of an independent contractor, the High Court determined that the principal factor which turns or determines rather the nature of an independent contractor arrangement is the terms of a contract. So in simple terms, the decision outlined if the contract specifies the relationship to be that of an independent contractor and parties voluntarily entered into that contract, well, then the court should respect the relationship that the parties created. Yeah. Now, the proposed legislation turns that back on its head and effectively overrules that decision, which states that effectively the totality of the relationship will again be the assessment criteria in determining whether an individual is properly considered to be an employee or an independent contractor. Now, this unfortunately sets us back some time in that we are now in somewhat of an ambiguous state and we need to reconsider the terms of engagement, the nature of the engagement, the way in which that engagement is reflected upon others, to avoid issues such as sham contracting findings or back payment of permanent employment rights. Another significant area of change is that of what is generally referred to as wage theft. Yeah. Now, this is somewhat controversial given the significance of the legislation, but I do think that effectively it will go through Parliament without significant amendment, given that it is aligned with society's expectation that employees be paid appropriately for the efforts that they contribute. So broadly speaking, we've seen a large number of matters, 7-Eleven and others, where there are ongoing significant underpayment of wages. It started with 7-Eleven, we've now seen a number of examples in some of Australia's largest employers, including Woolworths and others, where the value of those underpayments are significant. The new legislation seeks to significantly implement a more robust penalty structure, including the criminalisation of wage theft for those employers who intentionally underpay employees. Prosecution can be taken by the Commonwealth Department of Public Prosecution or the Australian Federal Police, and there are greater penalty regimes, including 10 years imprisonment, the greater of 3 times the underpayment, or up to $1.5 million for an individual or almost $8 million for a corporation. Having said that, the Fair Work Ombudsman does have the discretion to enter into a cooperative agreement with an employer concerning any identified underpayment, which would prohibit that criminal prosecution by the Department of Public Prosecutions, or where a small business has undertaken steps to comply with a small business wage compliance code, which we anticipate will be shortly introduced by the Fair Work Commission. That of itself will result in the Commonwealth Department of Public Prosecutions being unable to proceed. So we do think that there needs to be some structured attempts to address the possibility of underpayment of wages within businesses' structures. And that of itself will go a long way to minimising the likely penalty which can apply and potentially removing the threat of criminal prosecution. Now, yeah, we're still waiting on the details of what the Small Business Wage Compliance Code and those cooperative agreements will look like, but you can be sure that where possible, we will be introducing innovative solutions to ensure that our clients are as compliant as possible and operating in a best practice framework. Lastly, as you would expect, there has been further significant penalties introduced in a number of other areas, including work health safety. Amendments have been introduced to introduce a concept of industrial manslaughter for various events which occur within an employment workplace or those operating a PCBU. Penalties have also been significantly increased, $18 million for a body corporate and 25 years imprisonment for an individual in relation to those industrial manslaughter offences. In addition to that, Category 1 offences have also been significantly increased, and that table there identifies that the penalty structure is substantially increased as a result of the proposed legislation. So for a body corporate, penalties have increased from 3 million to 15. Substantial PCBUs are now liable for penalties up to $3 million, whereas individuals are now on the hook for 1.5 million, as opposed to the prior penalty of 300,000, which they may have been subjected to. Category 2 and 3 offences have also been increased by approximately 40% as well as a result of the proposed legislation. Now, this of itself, I think, is significant. Also demonstrates the need to engage a professional organisation such as HR Assured to support you with both compliance from an employment relations, HR and work health safety perspective. Now, fully appreciate that some of these changes and their effect on your business are substantial and somewhat difficult to get across given the volume of changes which have been introduced this year. I'll now hand over to my colleague Adam, who will explain how we can be contacted and some of our colleagues can be of more direct support in answering some of your more direct or confidential questions that you may have. Thanks, Adam.
Thanks, Wes. Excuse me. So this is just a reminder that, again, if you are a little bit worried about what you currently have in place to protect your business in regards to the Fair Work Amendment, we are offering a free workplace compliance consultation with one of our team to see if HR Assured can assist your business. Again, it's a service that will uncover any hidden risks and threats to your business, navigate and understand if your business is compliant with workplace laws, give you some tips to help your business succeed and improve your workplace processes, and there are no obligations. So something else I'd just like to touch on here is the e-learning courses to mitigate risk and protect your business. So as Law and Wes have discussed, the new legislation, positive duty obligations, in response to that, we have built our comprehensive e-learning modules to make sure clients meet their obligations. And to be honest, this is just another example of how we continue to support our clients. And we've already had over 4,500 employees take this course, which we're actually quite proud of. So what it will do, it's a bespoke training that meets your legal obligations, protects your business and mitigates risks. It comes with HR Assured subscription and can be completed at any time. So let's have a look at some of the questions, or jump into them rather. So thank you to the attendees that have put their hands up to get some questions answered. We have had quite a few come in here, excuse me, and even some complex ones. So we'll get through as many as we can. I am conscious of the time, so if we can't get through your questions, we will get in contact with you. So the first question here, which I believe will be one for Wes, is there anything that I can start doing now to prepare for the proposed changes in 2024?
Yeah, and a really good question. I think it's probably a little bit broader than the proposed changes in 2024. I think that there are some things that should be considered now, as law has outlined, in terms of what has already occurred but will occur at the end of this year. So just generally speaking, contracts should have already been updated to remove the pay secrecy provisions. You should have already been implementing positive duty steps in relation to sexual harassment, including the consideration of the risk to your business, what policies, procedures, training, refresher training needs to be undertaken, as a broad example. In December, we have the termination of zombie agreements. So if you are operating under a zombie agreement and haven't acted yet, you've got very limited time left in order to address that. And I would be strongly suggesting you reach out to a professional advisor as a matter of urgency. In December, we also have the additional provisions around the limitation on fixed-term contracts coming in. So for anyone that's engaging fixed-term employees or max-term employees, you should really be considering that engagement model before December. In contemplation of the closing the loophole provision, whilst, as I said, there's changes anticipated, it's inevitable that there are going to be legislation, despite its final structure, which significantly increases penalties around wage theft, significantly changes the concept of casual employment, significantly changes the rights and entitlements of independent contractors. So if you haven't done anything yet, I would be considering that it's important to undertake a degree of review internally around your compliance with wage obligations, particularly where you employ people under a modern award or pay close to a modern award structure. I'd also be closely reviewing your engagement structure around casual employees and independent contractors, because there's a lot that can occur there. And the significant increase in penalties under the WHS legislation as well, I also think serves as a very timely reminder that if you're not completely across your WHS obligations, if you haven't undertaken due diligence, if you're not confident in the WHS systems that you've put in place, then you need to do that as a matter of urgency. Otherwise, you as an officer of the organisation and the organisation itself now stands liable for some pretty hefty penalties if there's any injury or death that occurs in the workplace. So there's a lot there, Adam, and I do think that businesses sometimes consider the range of obligations as being overwhelming. One of the beneficial things I think that our service delivers is the ability to break those obligations down into manageable solutions. And you're not required in many instances to do that all at once, but rather what we should be doing is identifying which aspects of those requirements and new obligations present more of an exposure to you and your business, and then mapping out over the forward HR lifecycle when we're going to address those at times when you've got capacity and budget to do it. But really, each business is different. One business would be more exposed to wage concerns, another business would be more exposed to WHS concerns, another business will have greater utilisation of casual employees. So the order in which you do that analysis probably differs, and that's really speaking to, I think, the benefit of that initial audit that we undertake and help mapping out how you can address those particular obligations over time.
Awesome. Thanks, Wes. A couple more, as I am conscious of time, as I said. So I think this would be for you, laws around pay secrecy. So with respect to the pay secrecy prohibition, does this mean that employees will be able to walk around talking about their pay? And how do I stop that from happening?
Great question, and it's not the first time I've heard it either. Essentially, the short answer is yes. Unfortunately, if people wish to talk about their remuneration in the workplace, then they're able to, and that's actually the purpose of one of the purposes of this amendment is to allow, I suppose, transparency in relation, or to facilitate transparency in relation to pay, with a view that it's going to make employers who are not paying the same jobs the same amount, the people who are doing the same work for the same amount of money, it's going to make them accountable for that variation, with a view to closing the gender pay gap. So yes, look, of course, people might be concerned that people are going to walk around talking about their remuneration. If you have a concern because you're paying people differently, we certainly suggest that you touch base with us, because we can give you some support in relation to how you could maybe review your remuneration structures, your skills matrix in relation to the different roles that you have. But if you're paying people the right amount for the work that they do, you shouldn't have anything to worry about.
Thanks, Law.
No
So just
worries.
one more here. I only bought my business in the last 3 years from the original owner. Can I get in trouble for wage theft from when the original owners were in charge? Because now I'm the current owner.
Okay, I'll jump in and take that one. It's one of those it depends answers. So ultimately, it depends on the manner in which you acquired or purchased the business. When you purchase a business, you can acquire it in two different ways. One, you can purchase a business by acquiring the shares of a corporate entity. So that corporate entity will continue, but you're just the sole shareholder from a given date, which means that that business is ongoing, unaffected, and you will be potentially, or that company will be potentially liable for any underpayment backdating 6 years. Where you acquire the assets and goodwill of a business and then offer to transfer employees over, well, then typically any form of underpayment liability will be limited to the date upon which you commence employing those individuals. So I'd have to say that it's a depending scenario. Don't mean to back out of the answer. But it's one of those scenarios that we would need to scope your particular circumstances further before we could give you definitive advice. And I think it's a great example of where we can add value by clicking on the QR code and speaking to one of our experts if you are needing to get further advice in relation to that transfer of business question.
Thanks, Wes. And yeah, just to reiterate that, if you did put a question and we haven't got to it, it is something that you are really stressed about, then please definitely use that QR code and utilize that free trial call. Otherwise, we will reach out to you. So that is it from us today. Thank you so much for spending the time with us again to watch the webinar explaining the proposed Fair Work Amendment Closing Loopholes Bill. We hope you took advantage of the initiatives we're offering, but more importantly, walked away with information that's valuable to you. We do these type of webinars regularly, so keep a lookout. We'll be in contact with you soon. Take care, stay safe, and enjoy the rest of your day.
Thanks, everyone.